Welcome to the Van Ryn Legal and Property Podcast, your trusted guide to real estate and legal solutions across borders.
So you've sent us some really interesting stuff here. And yeah, if you're trying to figure out the difference between like a short-term apartment rental and actual hotel services in Russia,
Yeah.
well, it can feel a bit like a legal maze.
Uh-huh.
And that's exactly what we're going to dig into today.
Yeah, it seems like there's this real tension, doesn't it? You've got property owners renting out flats for short stays, maybe like Airbnb style.
Right.
But then you've got neighbors in the same building worried these places are turning into, well, basically unofficial hotels.
Exactly. And the sources you sent reflect that. We've got rulings from the Russian Constitutional Court, specifically from October and March 2023.
And also those updated regulations, the ones on providing hotel services, right?
Good.
From December 2024.
That's the one. So our mission today is really to sort this out, clarify the legal lines, understand the criteria they use to tell these apart.
And figure out what it actually means for people, property owners, but also just residents living in these apartment buildings.
Okay, so let's kick things off. How did this even end up in front of the Constitutional Court? It sounds like it started with one specific case.
It did. It seems a property owner who was registered as an individual entrepreneur was basically stopped by the lower courts from using their apartment for what they called hotel services.
Stopped by the courts based on what?
Based on Article 17, Paragraph 3 of the Housing Code. Essentially, the rule that says you can't run a hotel in a residential building. And interestingly, the case was brought by a neighbor.
Ah, the neighbor complaint. So what was this owner actually doing that made the courts think hotel, not just rental?
Well, that's the crux of it. It wasn't just about letting someone stay for a few nights. The evidence showed, for instance, the apartment was advertised online using hotel language, like calling it a number or two-level apartment.
Okay, so the marketing language was a factor.
Definitely. But also the services offered. Things like airport transfers, providing food and drinks, even having English-speaking staff available. Extras that go beyond just providing accommodation.
Right, that sounds much more service-oriented than just handing over keys. So the owner then took this up to the Constitutional Court, arguing the law was fuzzy.
Exactly. Their argument was essentially, the law is ambiguous. It lets courts blur the lines between a legitimate short-term rental, which they felt they were doing, and running an actual hotel service. And this ambiguity, they argued, infringed on their basic rights as a property owner.
So they weren't trying to argue for hotels and apartment buildings, just for clarity on what counts as one.
Precisely. And the Constitutional Court seemed to get that. They weren't there to question the general ban on hotels and residential spots. Their focus was really on, does the current law actually let us reliably differentiate between a short-term rental and a hotel operation?
Okay, because without that clear line, you can see how owners' rights might be impacted.
For sure. The court acknowledged that fundamental right under the Civil Code for property owners to lease out their property.
All right, so what did the Constitutional Court actually clarify? What were the key principles they laid out?
Well, first off, they really doubled down on that right to rent. They stressed that under the Civil Code, owners can enter lease agreements. And crucially, neither the Civil Code nor the Housing Code says anything about a minimum lease term.
So technically, renting for one night is perfectly legal under basic property rights.
In principle, yes. The act of leasing itself, regardless of duration, is protected. That doesn't automatically make it a hotel service.
Okay, that's a big point. What else? Did they address the business side of it?
They did. They noted that even though some specific national standards for, say, small B&Bs were canceled, it doesn't mean short-term renting isn't a valid economic activity. They pointed to things like the tax system. There's a specific patent system for income from renting out property.
Ah, so the taxman recognizes it.
Right. And also the official economic activity codes, the OKVED codes, there's actually a specific code for activities for the provision of short-term accommodation, which is separate from the codes for hotels.
Interesting. So different government bodies already sort of distinguish it.
It suggests they do, yeah. So the court basically said, short-term rental, even very short, isn't automatically hotel services and doesn't inherently clash with rental laws or the ban on hotels in residential buildings.
But they didn't just leave it there, did they? They also said that hotel services aren't only provided by official hotels.
Correct. That was a key clarification. Just because you don't have a sign saying hotel doesn't mean you're not providing what legally amounts to hotel services.
And the flip side, just because you offer, say, Wi-Fi or clean towels, doesn't automatically make it a hotel.
Exactly that. Offering some amenities you might find in a hotel doesn't instantly transform a rental into a prohibited hotel service. The crucial thing, the court said, is looking at the fundamental characteristics. Is it acting more like a rental or more like a hotel operation?
Okay, that still sounds a bit gray. How are courts supposed to decide? Did the Constitutional Court give any concrete factors?
They acknowledged there weren't clear-cut legal criteria set in stone. So they said courts have to look very closely at the specific facts of each case. But they did highlight some crucial factors.
Like what? What should courts be focusing on?
The biggest one seems to be inconvenience to other residents. Is this rental activity causing disturbances, noise, traffic, constant strangers that go way beyond normal apartment living? That's a major red flag.
That makes intuitive sense. Lying next to what feels like a busy hotel lobby would be disruptive.
Definitely. It's about the impact on the neighbors' right to quiet enjoyment of their own homes.
What else?
Another big one is the intensity of use of common areas. Are the hallways, elevators, entryways getting significantly more wear and tear than usual, like you'd expect from a hotel's constant guest turnover?
Okay, so the physical impact on the building itself.
Yes, and they also mentioned using hotel-like terms in advertising like number or apart hotel. While that alone isn't proof, it adds to the picture if other factors are present.
What about bad guests? Does that count?
Interestingly, the court said negative guest behavior on its own isn't a determining factor. Why? Because unfortunately, you can have disruptive long-term tenants too. Neighbors already have legal tools like a negatory claim to deal with nuisance behavior regardless of how long the person is staying.
Ah, okay. So it's not about individual incidents, but the overall operational pattern and its effect on the community and the building.
Exactly. Is the operation itself creating hotel-like impacts?
Did the court give examples of things that would strongly suggest it as hotel services? Like specific red lines?
They did give some pretty clear examples. Things like equipping the apartment to house way more people than typical for residential use.
Like bunk beds everywhere.
Potentially, yeah. Or regularly having a high turnover of large groups. Also, renting for less than 24 hours, that looks more like hotel timing.
Okay. What else?
Renting the space for non-living purposes, parties, events, meetings, that's not typical residential use.
Right.
Another big one, having staff regularly present in the common areas, servicing the guests like hotel staff would.
So someone constantly buzzing around, handling check-ins, cleaning.
Yeah, that kind of visible, ongoing service presence. And finally, if one owner is running multiple short-term rentals in the same building, that definitely raises the question of whether it's functioning more like a hotel operation.
Those examples really help visualize where that line might be crossed. So after laying all this out, the Constitutional Court didn't actually strike down the law itself.
No, they found the challenged norm, the ban on hotels and residential buildings, was constitutional as interpreted by them. They felt their explanation clarified the ambiguity.
But they did nudge the lawmakers.
Yes, they explicitly told the lawmakers to create more specific regulations for short-term residential rentals. The goal is to better balance everyone's interests: owners, renters, permanent residents. They even suggested special rules might be needed for tourist areas or resorts.
So more detailed rules might be coming down the line.
It seems likely. And importantly, the specific case that triggered all this, Pavel Bakarev's case, has to be reviewed again, applying this new interpretation.
Okay, so the court provided a framework. Now, let's connect this to the other source, the regulations on hotel services. How do the formal rules for actual hotels shed light on this?
Well, this government decree, number 1853, lays out the detailed operational rules for any place legally operating as a hotel in Russia. Looking at these rules really highlights the differences.
How so? What's in there that you wouldn't typically see with a short-term apartment rental?
For starters, it gives a precise definition of hotel services. It also emphasizes the whole system of official classification, the star ratings. Hotels have to be categorized.
Right, you don't see star ratings on apartment listings usually.
Exactly.
Wow.
And there's a strong focus on having a formal contract specifically for hotel services, which is different from a standard lease agreement.
What else stands out?
The amount of information disclosure required. Hotels have to prominently display tons of details: their registered name, address, legal info, their star category, room prices, exactly what services are included, payment methods, booking rules, check-in out times, internal house rules.
Wow, that's a lot. Much more than you'd typically get up front from a private rental.
Absolutely. It has to be readily available. The decree also specifies booking procedures, differentiating between guaranteed bookings, where they hold the room for you, and non-guaranteed ones.
What about knowing who is staying? Security aspects.
Yes, very strict rules on guest registration. Hotels must collect and verify ID documents for every guest. They also set standard check-in and check-out times, usually noon check-in, noon check-out, unless specified otherwise.
And liability. What if something gets stolen?
The regulations cover that too. They detail rules for payment, handling extra services, what happens with lost property, and significantly, the hotel's legal responsibility for the safety of guests' belongings kept in the room.
So you compare all these formal, regulated requirements for hotels.
To the usually much more informal setup of a private short-term rental, the differences become pretty stark. The absence of these formal structures, the detailed registration, the specific service contracts, it all supports the Constitutional Court's idea that you need to look at the overall nature of the operation.
It really paints a picture of a regulated service industry versus a simpler property transaction.
Precisely. The hotel regulations show what a formal, regulated hotel operation looks like, making it easier to see when a short-term rental is or isn't crossing into that territory.
Okay, so let's try to wrap this up. The key takeaway seems to be that telling the difference between a short-term rental and a hotel service in Russia isn't just about how long someone stays.
No, definitely not.
It's really a combination of factors, but the big ones seem to be the impact on neighbors, the level of disturbance, and how intensely the building's common areas are being used.
Those seem paramount based on the court's reasoning.
And while offering extra services, like those transfers or meals, is relevant and points towards hotel activity, it's not the single deciding factor on its own.
That's a good summary. Just putting your apartment up for short-term rent isn't automatically illegal. But if you start operating it in a way that mirrors a hotel, causing significant disruption, high wear and tear, offering extensive services, that's when you risk falling foul of the rules against hotels and residential buildings.
And this whole area is still developing, right? With the court calling for more specific laws.
Absolutely. It'll be interesting to see what specific regulations emerge to try and strike that balance they talked about.
It really makes you think, doesn't it? Considering these distinctions, what does this mean for the broader sharing economy? You know, platforms like Airbnb versus traditional hotels, especially in residential areas.
Yeah, and what responsibilities fall on everyone involved? The property owners, sure, but also the renters themselves in terms of being good temporary neighbors and keeping things harmonious.
Definitely food for thought. It's about finding that balance between property rights and community living.